silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas.
That right, there's your first reality check. The judge isn't just throwing out warnings. This is real talk first offense. You're already looking at jail time and thousands and fines. You're good to drive. After just 2 drinks, think again. This courtroom sees how that plays out every day.
On arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .179 and .175.
Where was he? Was he in the middle of the road?
It sounds like... Yeah, I know. So it says that he was sitting inside his vehicle on the 400 block of West Gray Street, which is accessible to the public. On a public road.
Oh, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it...
0. 179. That's more than twice the legal limit. He was asleep in a running car and drive, foot on the brake. That's not just dangerous. It's a ticking time bomb. Do you want your kid crossing the street next to that?
On a public street. It says, well, more specifically, it says 400 block of West Gray Street is a public street.
I need more information. Does it say he's a street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400 block of West Gray Street is a public street. It doesn't say specifically.
It doesn't ask him if he's driving, doesn't have none of that. Really.
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's something further stated on that.
I'm sorry. I'm going to find no probable cause. I can't just go forward with assumptions here, Mr. Cleary, be safe, man. We have every single day. Look, this weekend, how many people died on the road here in Harris County? Really, be smart. You have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay? Please take a seat, sir. I'm going to find no probable cause.
All right, Judge.
Just like that case dismissed. Why? Because even with the drunken drive gear set up, the court can't run on assumptions. If a location isn't clearly stated as public, the probable cause vanishes. That's due process, folks. Messy, but necessary.
Door, Adam.
Mr. Dory, you're charged with assault with a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Yes, sir.
Officer was dispatched to a disturbance. The complainant and the defendant are in a dating relationship. The complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain.
From DUI to domestic assault, we're switching lanes fast. And here's where it gets heavy. Visible bruises, a scratch, and allegations of multiple schwies. Judges don't play when there's physical evidence in a domestic case.
Complainant to have a scratch on her chin, scratches on her arm, and a large purple bruise on her right arm.
Know that he hit her? Do we know?
So the complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain.
All right, Mr. Dorn, we're going to find that there's sufficient probable cause to go forward with your case. This case is 1,139 days old. If you take off again, I'm going to make the bond so high, you'll have hair falling. Do you understand?
Yes, sir.
As it stands now, I'm going to put an ankle monitor on you so I know where you are at all times. You will have the GPS monitor. I am now also issuing a protective order that you're not to have any contact with this person whatsoever. Miss Ray Perez is now a protected individual. You cannot commit family violence or an assault against this person. Commit and act in furtherance of an offense under Section 42.07
Make the bond so high you'll have hair falling. Do you understand? Yes, sir. As it stands now, I'm going to put an ankle monitor on you. So I know where you are at all times. You'll have a GPS monitor. I am now also issuing a protective order that you not have any contact with this person whatsoever. Miss Ray Perez is now a protected individual. You cannot commit family violence or an assault against this person committing acting. Further on an offense under Section 42, 072 of the Texas Code. Make the bond so high your hair will fall out. That's not just a warning, that's courtroom poetry. When a judge talks like that, you know you're on thin ice. Mess around again. And you're not just going to jail, you're going deep.
Fucking statute. You not threaten, harass, be in possession of a weapon, or go within 200 feet of where she lives or where she works. Do you understand? Yes, sir. If you violate this protective order, the state can and will file a violation protective order if it's one of the worst cases you can pick up. Do you have a lawyer today? No, sir. What are you doing about that? Yeah, file one. Okay, we will give you time. I'm telling you now, I'm fast tracking this to trial. In 30 days, it's discovery complete.
Discovery, it looks like we are missing some photos potentially, but besides that, discovery is...
If you can try to get on it. 30 days, I'm putting this case to trial. Do you understand? It would behoove you to immediately go out there and start trying to find a lawyer. I'm going to have you go to Victoria, sign a reset. After that, you'll get with Fleischer for your bond conditions. I'm going to have you take a seat while we create all the documents while you sign it, and then you'll be free to go, sir. Yes, sir. Yes, sir. Mr. McIntosh, you're charged. You're on bond for a theft. You've now picked up a new theft. On the new case, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6, 2025, an officer was dispatched to a shoplifting call at Walmart in Harris County, Texas. The officer made contact with the asset protection staff. The complainant stated that he recognized the defendant from a previous encounter. The complainant observed the defendant grab multiple items and attempted to leave the store, passing all points of sale without attempting to pay. The defendant stated he owned a Purple Heart Veterans discount, and therefore the amounts
That was the first step, right? I remember that from the first step. That's 254, right?
Right. So, no, this is 255. So maybe similar facts.
That's the exact, then that must be the exact same as the first one.
Let me check. Right. Yeah, that's what I thought. So the older theft is from December 16th, 2024.
Right.
And that was from Melrose, and this is from a Walmart, and this is on March 6, 2025. I'm not seeing anything on the previous theft regarding the Purple Heart discount.
Okay.
Yeah, start over.
So, to Walmart and how much?
It's $283.62.
Judge, if you can recall, this is the young man that you had granted a pretrial. You had given a bond for him. You had me to talk to his mother to see if his mother would have a place for him to stay. And she said yes, provided that he puts up an effort to try to get a job and etc.
I remember that. Okay. But you now picked up a new case.
Now,
Have we addressed that since then?
Yeah, we addressed it. We knew that he had picked up another case. That's why you were upset that he had picked up another case while he was on bond for the previous theft. But the court was kind enough to still give him a bond because I had spoken with the mother, and the mother informed me that he could stay there and until such time that he.
Why are we doing another arraignment today?
Yeah, bond conditions have already been set for this.
Why are we doing an arraignment? Is today just a regular setting then? I'm showing them both set for.
They were signed. Door? It's I guess it was just a regular setting.
Don't-
A PR bond, and on the
Right.
bond, it had today's date of building.
If you pick up a third case, I'm going to absolutely lose it. Do you understand?
Yes, Your Honor.
You must get a job or be in school full time.
Yes, Your Honor.
Do not use any illegal drugs. If I find that you're using, I will lock you up. Do you understand? We've given you now 2 PR bonds on the first one, 1 PR bond on the second case. That's 3 PR bonds. You will not get another one. Do you understand?
Yes, Your Honor.
In the next couple of weeks, I'm going to send you for a drug test. If I find that you're using, it's not going to go well for you. Okay, so I guess let's set this case out for a couple of weeks, because I want to know what he's done to get a job. I'm setting your case out for 1 to 2 weeks. I want to see what you have done to get a job. If you have done nothing, if you come here and show me that you have not filled out at least 10 to 15 applications for a job somewhere, it's not going to go well for you. Do you understand?
Yes, Your Honor.
Alright, so 1 to 2 weeks, you're going to get tested when you come back.
Yes, Your Honor. Yes, sir.
Alright, Mr. Thank you, Your Honor.
Thank you.
Have a seat. Thank you, sir.
Right, Judge? Yes. Approach on Mr. Perez for 1 minute. May I call him up?
Yeah, please.
Ricardo Perez.
Is this all you have to take?
No, I've got other ones I need to talk about.
What is the case number?
It is 255-6010.
Buenos días, señor. No puedo decir.
Whereas you were charged with assault, bodily injury, you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay, plan. Good morning.
On March 16, 2025, officers were dispatched to an assault with injuries located at 4000 Hollister in Harris County, Texas. The officers were unable to speak with the complainant because his injury caused him to be unconscious. Officers reviewed surveillance, which showed that the defendant pushed down the complainant with both of his hands, causing the complainant to hit his head first on the concrete. It also showed the complainant to be unconscious. The defendant was identified through a witness who called him out on the scene and identified him. And the defendant matched the person in the surveillance
Where
footage.
was this? At a bar? You're drinking what?
It doesn't state, it just gives an address.
I believe it was at an apartment complex where he resides. My understanding. I guess we'll see what the surveillance shows.
Mr. President, I want to find that there's sufficient probable cause to go forward with your case. I want you to understand that I'm going to do everything in my power to protect my city at all costs. This is now your second assault within the last year and a half to 2 years. If I find that you so much